Yeah, I think it's twofold. I think there's certainly if you want to call it the non-legal or the public uh, aspect of it, which is to try and put an end to this claim or idea that this was somehow accidental. From a legal perspective, it turns into it turned into both pre-trial and at trial a very nuanced issue for us because in Virginia, punitive damages are capped at $350,000 statutorily. So you can get a $200 million verdict on punitives, and the judge is going to write you a judgment for $350,000, and you can't tell the jury. You can't look at the jury and say, "Hey, all I get is 350." You're statutorily prohibited from doing so. At the same time, in the bankruptcy code, there is an exclusion in terms of liabilities or that can be excluded in bankruptcy for willful or malicious injury. And there are rulings in the bankruptcy code that have found that intentional acts don't necessarily qualify for willful or malicious injury because depending on the state, and willful or malicious aren't elements of an intentional crime, and so or an intentional tort, and so sometimes you have to retry a case in bankruptcy just to establish that there was willful or malicious injury, and so there's no saying for certain that that's going to be avoided because you never know who you're going to get in front of in a bankruptcy court, but we felt that George Hughley was convicted of second-degree murder, which in Virginia comes with a jury instruction that requires the showing of malice. Now, when we get to the wrongful death civil case in Virginia, wrongful death actions are statutory. It's like that in most states because people used to die and the torts died with them, and so there's all these statutes created in most states to be able to give beneficiaries this right of civil suit. And in Virginia, I think this is just a General Assembly error, but the wrongful death code doesn't require a showing of malice. It requires just a showing of willful or wanton conduct or conduct that evidenced willful and wanton behavior or reckless indifference. And so we felt that if we can have a jury come to a concrete finding of willful or wanton or reckless indifference and a showing of punitive damages, and we could couple that with a conviction of second-degree murder that required the showing of malice, that if we were to come in front of a bankruptcy judge, if we ever have to in the future, we felt that in briefing, when you put those two things together, you can say, Judge, a jury's already decided malice, a jury's already decided willful wanton. That's malicious and willful injury. Let's skip all of the necessary, trial procedures in the bankruptcy court and find that this debt and this liability is non-dischargeable. So that was sort